to order. Sergeant at Arms will please secure the chamber doors. Members, please take your seats. Madam Clerk, please call the roll.
Mr. President.
All right, Senators, on this Friday, March 14th, which I think is actually the Red Moon Day, we are so pleased to have Rabbi Rachel Ackerman of Temple Shalom in Chevy Chase, Maryland, guest of the distinguished senator from the 18th District. Please rise for the invocation.
Mr. President, Senators, thank you so much for having me here today, and thank you so much to Senator Waldstreicher for the honor, as always, to join you this morning. Members of the Maryland State Senate, today is the Jewish holiday of Purim. It is one that is typically imbued with exuberant joy and raucous celebration, adorned with special foods and carnivals, costumes, and gift-giving. It celebrates the bravery of Queen Esther, who saved the Jewish people from the evil Haman's plot to exterminate the Jewish community. On the day when the Jews were to be murdered and instead survived, the book of Esther teaches, the Jews enjoyed light and joy, happiness and honor. But Purim observances over the past several years have had a heaviness around them. Last year, still reeling from the atrocities of October 7th, and this year, on this day, in addition to that ongoing trauma, I struggle to find the strength to embody joy amidst the suffering of so many in my congregation and throughout Maryland. They are afraid, they are losing jobs, losing a sense of security, their futures unknown. And so this year, in place of joy, I yearn for Esther's bravery. I strive to emulate her commitment to her people, even though she was protected by the walls of the palace in which she was queen, her Jewish identity unknown to even the king. I hold in highest esteem how she spoke truth to power, despite the profound personal risks to her own safety. When it was clear that she was the only hope for survival of her people, even for the sake of her own safety, reminding her that even her security in the royal palace was likely temporary, and urging her, perhaps it is for a time such as this that you have arrived to a position of royal power. And so while I struggle to find joy and light and gladness this day, I do have a prayer to offer all of you, and that is this. May all of you who hold great positions of power allow yourselves to feel the burdens of your struggling constituents who are frightened and off kilter, who are grieving and desperately trying to find light amidst darkness, joy amidst suffering, happiness amidst pain, honor amidst shame. May you carry these pains on your heart, yet not be weighed down by them. May you heed the inner and outer calls to lighten these burdens, even when doing so is a risk, especially when doing so is a risk. Your constituents in this great state look toward all of you in your positions of power to muster Esther's bravery and to heed Mordecai's call. Perhaps it is for a time such as this that you have arrived to a position of power. We look now to you to transform these days from grief and mourning to festive joy. May you utilize esteemed positions of power so that we may all know one day soon light and joy, happiness and honor, to which we say, Amen.
I recognize the senator from the 18th District.
Thank you, Mr. President. I woke up angry at the world today. We are one day away from crossover. My wife's livelihood is being determined on Capitol Hill this morning, but I found a salve in my friendships in this chamber and the presence of my rabbi, Rabbi Rachel Ackerman, and her kind words make me feel better today. She is joined by her husband, Rabbi Jake, on the floor, and I would move that her very kind remarks this morning be journalized.
Without objection, most certainly we will journalize the invocation this morning. Thank you, and thank you for your service to the community, and thank you for being here with us today. Thank you. All right, has everyone recorded their presence? If so, the clerk will take the call. With 43 members in the chamber and a quorum being present, the Senate of Maryland is again in session. Do we have any introductions today? Introductions. Recognize the senator from the 27th.
Thank you, Mr. President. If I could also have the attention of the senator from 26, I want to make sure I'm not completely stepping on his toes. I may defer to the senator. Senator, do you have an announcement? Sorry.
Recognize the senator from the 26th.
Thank you very much, Mr. President and colleagues. Today I ask the Senate to give a warm welcome to students from my legislative District 26. They're part of the District 8 Prince George's County Student Leadership Academy under the leadership of Councilman Edward Burrows III and his team. This program is designed to foster leadership, development, personal and professional growth, community service, and career exploration for high school students. The Academy aims to shape high school students and recent graduates into confident, capable, and community-minded individuals. This program includes workshops, trips, and hands-on training opportunities. Today we have students from Oxon Hill, Crossland, and Friendly High School in my district, and Councilman Burrows, when he was in the 12th grade, began working in my office as an intern, and now he is an esteemed councilman in our district. Got his start here. I am privileged and proud to have them. Would you please give them a warm Senate welcome?
Welcome, welcome. Great to see you all. Thank you so much for being here, and hope you all enjoy seeing our democracy in action, at least here in Maryland. We are functioning today. All right, Senator from Montgomery County.
Thank you, Mr. President. It is my distinct honor to introduce one of the most important constituents to me in District 16. If you see me smiling today, that is because my son Kenny is with me today. So please give him a warm Senate welcome. Thank you.
Oh, over there. Welcome, welcome. I was wondering where he was. Perfect, excellent. Great to see you. Great to see you.
Mr. President.
Yes, recognize the senator from Carroll County.
Thank you, Mr. President. This morning I have on the floor with me a man that's shadowing me, a constituent. It's Doug Smith from Mount Airy, and he's been real involved with us locally in a lot of different activism, especially in the area of education, and he wanted to come shadow, and he picked a very busy day to be able to come down.
Quite the day.
I asked the body to give him a warm welcome.
Excellent. Welcome. Welcome. Thanks for joining us. Yes, Senator from Howard County.
Sure. Thank you, Mr. President. I want to welcome our Doctor of the Day, Dr. Gary Pushkin, who is a orthopedic surgeon from Baltimore City, from my colleague in District 43's, who just is catching your breath. So I just wanted to do a proper introduction. Former MedChi president, 170th MedChi president, doing phenomenal work in Baltimore City for decades. Has been a renowned orthopedic surgeon up there in Baltimore City. So a warm Senate welcome for Dr. Gary Pushkin this morning.
Welcome. Welcome. All right. Any other introductions? No? All right. I guess we will jump in. All right. Schedule today. We're going to see how far we can get this morning. Let's aiming, 2:30. We'll see where we are at that point and kind of assess it then. We'll probably take just a couple of hours, now, maybe 2 hours at most in between, so that we will have a second session. Ideally, we can start it earlier so that we're not here to midnight. So we'll see how it goes. You never know, Senate of Maryland, so depends on the moment. So TBD, but that's the kind of general idea. So probably one committee session midday for 90 minutes or so at most. All right. Anything else before we jump in? If not, so be considered the reading of the journal from the prior legislative day. First order of business is a message from the House. This is number 16. Clerk will read the bills.
House Bill 261, Delegate Forbes, Estate and Trust, Priority Claims on an Estate, Unpaid Child Support, Judicial Proceedings.
All right. Majority Leader moves so be considered the reading of the bills. Let's go ahead and start with our Committee on Finance. We have quite a bit. Which bill is that? Which one? Goodness gracious. All right. This is report number 24 out of Finance. Clerk will read the first bill.
Senate Bill 43, Senator Augustine, Maryland Department of Health Forensic Review Board and Community Forensic Aftercare Program established, favorable to amendments.
Recognizing the senator from the 37th is the floor leader.
Thank you, Mr. President. Senate Bill 43 requires the Maryland Department of Health to establish a forensic review board at each facility that has persons committed as not criminally responsible. The boards are responsible for reviewing and determining whether to recommend to the court that a committed person is eligible for discharge or conditional release with or without proposed conditions. Amendment number 1 is technical. Amendment number 2 strikes provisions related to the codification of a certain community forensic aftercare program, establishes additional notice, representation, and other requirements related to the submission of statements to the board, requires a person's treatment team to implement any recommendations of the review board, and specifically authorizes the board to make recommendations related to the release of a committed person. I move the amendments and the adoption of the favorable committee report.
Floor Leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objection? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 43 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 423, Senator Bidel, Maryland Medical Practice Act and Maryland Physician Assistance Act revisions, favorable with 2 amendments.
Recognizing the chair of the committee is the floor leader.
Thank you, Mr. President. Senate Bill 423 was actually requested by the Board of Physicians. It alters, clarifies, and makes consistent provisions of law regarding physicians, physician assistants, and allied health professionals regulated by the Board of Physicians. Among other things, the bill alters disciplinary grounds and process, licensure requirements, board duties, notification requirements, and provisions governing the Allied Health Professional Advisory Committees. The bill alters existing civil penalties and establishes new penalties for specific violations. The bill also repeals obsolete and redundant language and makes clarifying and conforming changes. Amendment 1 is technical. Amendment 2 makes additional technical clarifying and conforming changes, defining employer and applying the term throughout the bill, eliminating duplicative reporting requirements, correcting a typo. Overall, it's just a technical rewrite of the Board of Physicians. I move the amendments and the adoption of the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? And any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 423 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 431, the President Registered Apprenticeship Investments for a Stronger Economy, RAISE Act, favorable with 4 amendments.
Recognize the Vice Chair of the Committee is the floor leader.
Thank you, Mr. President. Senate Bill 431 is an administration bill that establishes the Maryland Office of Registered Apprentice Development, the Registered Apprentice Qualified Intermediary Program, and the Maryland Apprenticeship Initiative Program and Special Fund. A 1-to-1 ratio of journeymen and apprentice for the apprenticeship is required, but the Maryland Apprenticeship and Training Council may recommend deviations for non-hazardous occupations. Also, with regard to the newly established programs, there are additional reporting requirements. The purpose of this bill is to increase access to apprenticeships in the state and increase the number of occupations that could benefit from apprenticeships. Amendments number 1 and 2 are technical and strike language that would substitute completion of an apprenticeship for completing licensure examinations in several occupations. Amendment number 3 makes clarifying changes, alters reporting requirements, and changes the name of a program and fund, specifies the time when the council recommends a deviation from the 1-to-1 ratio, strikes a mandated appropriation, and provides for retaining apprentices by employers after completion of the apprenticeship. Amendment 4 established the Registered Apprenticeship Advisory Board. I move the amendments and adoption of a favorable committee report.
Floor leader moves to the adoption of the 4 committee amendments and the favorable committee report. Any discussion of the amendments? Any objections? Without objection, the 4 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 431 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 495, Senator Ellis, Opioid Restitution Fund, authorized uses, favorable with 2 amendments.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President, colleagues. As stated in several other bills similar to this over the last few weeks, over 22,000 Marylanders have passed away due to opioid overdoses over the last 10 years. That's an average of 2 100,000 per year. And so many hundreds of thousands more of our citizens are affected. They didn't pass away, but they're affected by opioid. The Attorney General of Maryland was leader in going after the bad actors in the opioid space. Not just the manufacturers, but the people who actually sell these opioids unnecessarily to our unsuspecting citizens. But the Attorney General still have ways to go. There's still a lot of people to go after and to bring in additional hundreds and hundreds of millions of dollars. And this bill, therefore, authorized the use of opioid restitution funds for operating expenses and personnel costs for the opioid enforcement unit within the Office of the Attorney General, the opioid enforcement unit alone. There are two amendments to this bill. One is technical, and the Second Amendment has two provisions, calls for an annual report from the Office of the Attorney General, and also sunsets, terminates this bill after a 4-year period. Mr. President, I move the amendments and the adoption of a favorable committee report.
Floor leader moves for the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 495 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 749, Senator Kramer, State Board of Dental Examiners, applicants licensed or certified in another state, favorable.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. Senate Bill 749 requires the State Board of Dental Examiners to issue a license to a dentist or dental hygienist licensed in another state within 15 days after receiving the applicant's completed application if the applicant otherwise meets the requirements for licensure. The bill also specifies the requirements that a dental radiation technologist must meet to qualify for a certificate in this state. If an applicant meets the requirements for certification, the board must also issue the certificate within 15 business days after receiving the completed application. There are no amendments. There is no fiscal impact. The bill passed the committee unanimously. I move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 749 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 1005, Senator Benson, Federally Qualified Health Centers, Grant Program, Acquisition of Land, favorable.
I recognize the Vice Chair of the Committee is the floor leader.
Thank you, Mr. President. Great bill. Senate Bill 1005 expands the authorized use of funds within the Federally Qualified Health Centers grant program to include the acquisition of land for the construction of a federally qualified health clinic. There are no amendments, there is no fiscal note, and there was no opposition in committee. I move the adoption of favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 1005 is hereby ordered printed for third reading. All right, we're going to go to Triple E. This is report number 20. Clerk will read the bill.
Senate Bill 587, Senator Muse, State Government, Maryland Reparations Commission, favorable with one amendment.
Recognizing the President Pro Tem.
Thank you, Mr. President. This bill establishes the Maryland Reparations Commission, staffed by the Maryland State Archives, and the public historically black college or university represented as a member of the commission. The commission must study and make recommendations relating to appropriate benefits to be offered to individuals impacted by historical inequality. By January 1st, 2027, submit a preliminary report of its findings and recommendations, and by November 1st, 2027, submit a final report of its findings and recommendations to the governor and the General Assembly. Commission members may not receive compensation but are entitled to reimbursement for expenses as specified. The bill takes effect July 1st, 2025 and terminates June 30th, 2028. There is one amendment that is technical and adds sponsors. I move the favorable committee amendment and the favorable committee report.
Floor leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, recognize the minority leader.
Yes, Mr. President, can the bill amendment lie over under the rule?
The senator's motion is in order. The bill and the amendment will lie over under the rule. Let's go to Finance. This is report number 25. Clerk will read the first bill.
Senate Bill 365, Senator Kagan, Department of Commerce, Nonprofit Organizations, Navigator established, favorable with 2 amendments.
Recognizing the senator from the 28th as the floor leader.
Thank you, Mr. President. Senate Bill 365, another great bill from the sponsor. As you know, we have a lot of thousands of nonprofits in Maryland, some big, some small. And this bill basically established a nonprofit organizational navigator within the Maryland Department of Commerce. What's the purpose of the navigator? Provide technical assistance to nonprofit organizations in obtaining access and applying for state grants. Also help collect information on federal and other local grants that might be available to these nonprofits. And I know we've seen in the news where certain nonprofit CEOs have huge salaries. Well, we amended this bill to say that nonprofits who pay any employee over $250,000 are not eligible for this help of the navigator. We want our great nonprofits who mainly use volunteers and doing a great job to be able to get this help from the navigator. 2 amendments. 1, establish the bill as an emergency measure, and second amendment, as explained earlier, limit application of the bill. Also, there's a sunset provision to this bill for June 30, 2027. There was no opposition of the committee hearing. Mr. President, I move the amendments and the adoption of a favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 365 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 664, the President, Business Regulation, Miscellaneous State Business Licenses, Enforcement and Penalties, favorable with 2 amendments.
Recognizing the senator from the Middle Eastern Shore as the floor leader.
Thank you, Mr. President, also known as the Midshore. But Senate Bill 664, as amended, requires the Comptroller Learman to consult with certain stakeholders to study and make recommendations regarding the enforcement process for miscellaneous state business licenses issued under Title 17 of the Business Regulations Article. Amendment number 1 is technical. Amendment number 2 is as described, which is the bill. There is no fiscal impact. I move the amendments and the adoption of the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 664 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 750, Senator Kramer, State Personnel, Collective Bargaining, Faculty, favorable with 2 amendments.
Recognizing the bill sponsor as the floor leader.
Thank you, Mr. President. Senate Bill 750, as amended, grants collective bargaining rights to some part-time faculty at the University System of Maryland, Morgan State, and St. Mary's College of Maryland. A separate bargaining unit for part-time faculty is established at each system institution, Morgan State and St. Mary's College. Amendment 1 is technical and alters the title. Amendment 2 makes changes consistent with the bill's focus on part-time faculty. It defines part-time faculty and excludes adjunct faculty at certain campuses. I move the amendments and the adoption of the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, recognizing the senator from the 27th.
Thank you, Mr. President. Question for the floor leader.
Will the floor leader yield?
Could you,
Senator may proceed.
Thank you. Could you list those who are exempted out of this, please?
Exempted out?
Yes, sir.
So, as defined in the bill as amended, part-time faculty means non-tenure track, temporary, contingent or contractual adjunct employees of a system institution and it does not include the following: officers, adjunct faculty who teach a standardized, pre-designed, and temporary curriculum per course and whose status is temporary, contingent, or contractual on a per-course basis for a defined period of 12 weeks or less, or student workers.
Thank you, Mr. President, if I might.
Please.
Are there institutions that are exempt out?
The
of this as
global
well?
campus, the University of Maryland Global Campus is exempted out.
That's the only one?
Yeah, Global Campus.
That's the only one.
Yeah, that's my
Thank you.
understanding.
Thank you, Mr. President.
Thank you, Senator. All right, any further discussion on the committee amendments? Seeing none, any objection? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 750 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 767, Senator M. Jackson, Calvert County Sheriff, Deputy Sheriffs, and Correctional Deputies Collective Bargaining, favorable with 2 amendments.
Recognizing the senator from the 22nd as the floor leader.
Thank you, Mr. President. This bill establishes the right for full-time deputy sheriffs and correctional deputies in the Calvert County Sheriff's Office to collectively bargain and establishes a process for them to do so. The amendments are technical, and the Second Amendment alters the process as agreed on by all affected parties. I move the bill as amended.
All right, the floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 767 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 815, Senator Watson, Occupational Licensing and Certification on Criminal History, Prohibited Disclosures, favorable with 2 amendments.
Recognizing the vice chair of the committee is the floor leader.
Thank you, Mr. President. Senate Bill 815 makes several alterations to the existing statute provisions that prohibit certain executive departments from denying an occupational license or certificate to an applicant solely on the basis of criminal history of the applicant unless the department makes a specified determination after consideration of certain factors. The bill changes include 1, limiting application of the statute to Maryland Department of Labor only, applying the statute to all ex-offenders, not just non-violent offenders, prohibiting Maryland Labor from requiring an applicant for an occupational license or certificate to disclose specified criminal information as part of an application with certain exceptions, and expand the list of factors for consideration. Amendment number 1 is technical. Amendment number 2 limits application of the bill to 2 licenses types. It only applies to barbers and cosmetologists within the Maryland Department of Labor. There is no fiscal impact. I move the amendments and adoption of favorable committee report.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 815 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 848, Senator Gazzone, Public Health Abortion Grant Program, Establishment, favorable with 1 amendment.
Recognizing the senator from Anne Arundel as the floor leader.
Thank you, Mr. President. Senate Bill 848 establishes the Public Health Abortion Grant Program and Fund in the Maryland Department of Health to provide grants to improve access to abortion care clinical services. Under the Affordable Care Act, carriers that cover abortion services are required to add $1 per person to the insurance premiums and must hold this money in a segregated account that can only be used for abortion care clinical services. The carrier's segregated accounts currently have upwards of $19 million in funds collectively that can only be used for abortion care clinical services. The bill requires the insurance commissioner to order the transfer of 90% of the unused funds as of December 1st, 2024 from the segregated accounts by September 1st, 2025, and the governor must allocate $2 million of this initial transfer to the new special fund. The commissioner must continue to annually on July 1st transfer, and the governor must appropriate to the special fund 90% of the ending balances of the segregated accounts that remain after 15 months from the end of the plan year have elapsed. Amendment 1 is technical. I move the amendment and the adoption of the favorable committee report.
Floor leader moves the adoption of the one committee amendment and the favorable committee report. On the amendment, recognize the senator from the 38th district.
Thank you, and good morning, Mr. President. Would the floor leader yield for a couple questions?
Yes.
Senator may proceed.
As I understand this bill, and I'm really looking to better understand the details, Senate Bill 848 establishes the Public Health Abortion Grant Program. Can you explain the funding source for the abortion grant program?
Sure. Under the Affordable Care Act, carriers have to, there's a segregated account. You'd use $1 from premium. So those plans that are obtained through the exchange, they collect $1 a month in premium, so $12 per year. It's put into these segregated accounts. It can only be used for abortion services.
So with these carrier accounts, are you saying, is there any flexibility that the funds can be used beyond abortion, for example, for pregnancy care and other reproductive care services?
No, these have to be used for abortion services.
So with this funding source, do the people who pay into these carrier accounts know that the money specifically is going into this abortion grant program?
No,
They do not know.
not to my knowledge, no. No.
Do we know how other states are using these carrier accounts? Do we know if they're using them for other women's health services beyond abortion?
It's my understanding that the federal law requires these to only be used for abortion care services. I don't know, I can't speak to what other states are doing, but I know that under the Affordable Care Act, it can only be used for abortion care services, these segregated money.
Mr. President, for purposes of an amendment, I'd like to lay over this bill.
Actually, I'm sorry, I just wanted to correct something real quick, Mr. President. It's my understanding that there is indeed, you asked, the senator asked whether there is notice to the individuals that are paying for these insurance premiums, and there is a notice that's provided at the bottom of the insurance premium bill, so I just wanted to correct that.
Okay, so it's in the fine print that this is where
There's notice that's provided.
okay. Again, for purposes of an amendment, may I lay over the bill, please?
Senator's motion is in order. The bill and the amendment will lie over under the rule. All right. Let's stick with finance. Calendar 26. Clerk will read the first bill.
Senate Bill 972, Senator Lamb, Anne Arundel County Board of License Commissions, alterations, favorable with 2 amendments.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. Senate Bill 972 increases from 3 to 5 the number of members of the Anne Arundel County Board of License Commissioners that the governor must appoint. It also alters the appointment process and eligibility requirements for board members and alters the license application process. There are 2 amendments. The first is technical, and amendment number 2 alters the process for selecting board members, prohibits the board from using certain information as a factor in licensing, and alters the penalty structure. There was no opposition at the committee hearing. There is a letter of support from the Anne Arundel County Senate delegation. Move the adoption of the amendments and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 972 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 1008, Senator Hayes, Economic Development Small Business Guarantee Fund, alterations, favorable with 2 amendments.
Recognize the Vice Chair of the Committee is the floor leader.
Thank you, Mr. President. Senate Bill 1008, as amended, modifies the Maryland Small Business Development Financing Authority's long-term guarantee program by specifying that the guarantee provided under the program may be supported in additional forms that under current law, including by 1, an irrevocable letter of credit, an official treasurer's check, 3, funds on a deposit in escrow or other depository account, and 4, any other legal instrument promising a financial institution restitution or reimbursements for its loan losses within the limits of the guarantee. The terms of the condition of the legal instruments described may not be onerous as to discourage the financial institution from offering the loan. Amendment number 1 is technical. Amendment number 2, language that would have authorized the guarantee to be supported by the full faith and credit of the state, has been deleted. There are no opposition at the committee hearing. I move the amendment and adoption of favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 1008 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 1023, Senator C. Jackson, Employment Discrimination, Fire and Rescue, Public Safety Employees, Use of Medical Cannabis, favorable with 1 amendment.
Recognizing the senator from the 8th District as the floor leader.
Thank you, Mr. President. Senate Bill 1023 prohibits an employer of a fire and rescue public safety personnel from taking any adverse action against an employee based on the employee having a valid written certification for medical cannabis or a positive test for cannabis while holding a valid written certification. However, an employer may still adopt policies prohibiting such an employee from using cannabis and being impaired by cannabis while on duty. Amendment number 1 is generally clarifying. There is no fiscal impact. There was no opposition at the committee hearing. I move the amendments and the adoption of a favorable committee report.
Floor leader moves for the adoption of the 1 committee amendment and the favorable committee report. On the amendment, recognize the senator from District 4.
Is this do I need to wait until he adopts or until we adopt the amendment, Mr. President? I want to ask the floor leader a few questions about the bill.
Now would be fine.
Okay.
Question for the floor leader. Does the floor leader yield?
Yes.
Senator may proceed.
Senator, I'm looking through this bill, and obviously this didn't come through my committee, but I have a couple concerns about when we start allowing our fire and EMS employees to use cannabis. So I'm just curious as to what the measurable standard is for ensuring that they're not under the influence at the time that their EMS providers are showing up to our loved ones and providing emergency services to them. Because as far as I know, as far as I've been told, the measurable standard is nanograms, and there is no, those nanograms stay in your system for a long while, for days after you use.
Well, there's guardrails in the bills to prohibit an employee from being impaired on duty. In addition, research shows that impairment rarely exceeds 10 hours, even with high doses of orally ingested THC.
So as long as they don't use within like 10 hours, you know, we're going to take their word. We're not testing them, knowing that they're taking these doses. We're not going to test them beforehand to make sure that they're able to safely render aid, because we can all say, I think we can all agree that cannabis is a depressant, slows your responses, your thought processes. So I'm not sure I want someone that's been smoking marijuana beforehand, who's not required to submit to a test prior to going into service on duty, rendering emergency services to someone who's in need of critical care, where literally seconds are a matter of life and death.
This bill is treating medical cannabis the same way we're treating it as opioids. In addition,
I couldn't hear you. I'm sorry, Senator. I couldn't hear you. It's treating medical cannabis as what?
As we're treating for opioids.
Right. But the difference is there's a measurable standard. You can actually determine right away if someone's under the influence of opioids, whereas under the influence of cannabis, there is no measurable standard that's accepted for impairment in the moment. Is that correct?
That's not correct. There's both a blood test and a urinalysis. In addition, every firefighter and fire officer is trained to recognize impairment. If a firefighter is unfit for duty, they can and will be removed regardless of cause. An example of that could be for like a high fever. A firefighter who has a high fever would be impaired and therefore cannot perform their duties.
I'm sorry, can you repeat that? I'm not following how that factors in.
every firefighter and fire officer are trained to recognize impairment.
Of their own, oh, okay, so you're saying of their peers, their
Yes.
friends. I
Yes.
see.
Let's see, Senator from District 12, what purpose does the senator rise?
To see if wanted to help with any questions and the questions from the gentleman from Frederick.
I yield to the senator.
Senator yields to the good doctor, Senator.
Yeah, so thank you. So just like any other occupation, if somebody arrives impaired, they can get tested, right? And so impairment, you know, our law enforcement officers are trained to be able to recognize impairment, and if someone's impaired, then they can send them for testing. So this would require that there be a process and a policy in place for testing to take place.
Okay, thank you for that, Dr. Senator. So my question is, on that topic, if someone were to show up at work smelling of alcohol right now, what would be the process that we would follow?
So if someone shows up at work smelling of alcohol, the employer could require that that employee go get tested with a blood alcohol test, for example.
Okay. And so I guess that's where, so that's one of the concerns is, so now that it has been decriminalized and used for recreational use, if someone shows up smelling of marijuana, are we changing the standard that now they're not allowed to be, if they still smell of marijuana, we can go and just take them right then and do a test on them?
So what this would do is set up a process for the employer to be able to do testing. So for example, for alcohol, there's a blood alcohol test that you can do on someone to be able to gauge their blood alcohol level. For cannabis, there now are tests being developed for oral swabs that people can have done to test whether they've had cannabis usage within the last 15 hours, for example. And so if someone arrives, in your example, having smelling of cannabis, that the employer can request that they go get tested if there's a policy in place for that local jurisdiction for firefighters to be able to use medical cannabis. It treats cannabis just like medical cannabis, just like every other cannabis use. So that the bill would require that the local jurisdiction set up a policy to do this.
So the oral swabs, though, is my understanding, is that they can record, they will document the use of THC or the presence of THC up to 3 days prior.
It could be up to 3 days prior. It should be no less than like 15 hours. So, but
it'll still show a positive if they've used. It could go up to 3 days prior.
It will show a positive, right? And so that individual, if they have prior, like a medical cannabis card and have filed that with their employer, right? The employer would be under jurisdiction to decide whether they could still be on the job or not, just like if it was blood alcohol level. Someone came in intoxicated, had a blood alcohol 0.1, got tested, came back 0.1, they'd be taken off duty, there'd be repercussions from that, et cetera.
So that's an excellent point.
I think on the medical questions, I think the good senator was very helpful. I think the floor leader's got.
Sure.
Yeah.
All right.
Thank you.
Thank you.
Thank you, Dr. Senator. So my question is then, we have, like the good senator said, that we have a standard that we can get an immediate standard of blood alcohol content for impairment or for alcohol usage. Is there a same standard available, testing-wise, available to get that type of immediate answer for impairment for marijuana?
No, there's not a current test. As the good senator said, there's something in development. But again, I will go back to every firefighter and fire officer is trained to recognize impairment. So that's the measure that.
They may be trained to recognize impairment. Are they trained to test for that impairment? So here's my concern, Senator, and the concern is that we're moving forward with minimizing the standard on what our first responders who are providing services to all of us and our loved ones across this state. There is no measurable standard that gives an immediate level of impairment available, unlike alcohol. So, and this bill would say that that we cannot, because of that, because there is no measurable standard, we are now putting employees in the crosshairs of facing punishment because there is no measurable standard within the certain guidelines that are dictated within this bill. So can you answer that as that what measurable standard that you're going to use that's going to meet the threshold of measuring that impairment within the 12 hours, which is what the bill says?
So the Maryland State Police uses field sobriety tests to measure impairment. So that could also be a way to measure the impairment.
So,
excuse me, just really, Senator, if you could hold the mic just a little bit closer. Thank you very much. Thank you.
So the Maryland State Police and standardized field sobriety test, they're not actually trained. That's actually for a DRE. SFSTs are not for impairment by THC. You have to have a drug recognition expert come in to test for impairment. So not every officer does have that training, unlike impairment for alcohol. Mr. President, I don't want to belabor this any longer. I'd like to, if I can, is it okay to special order the bill for purposes of an amendment?
Well, just,
or lay it over under the rule?
If Senator moves to lay over the bill, the motion is automatic. The bill and the amendment will lie over under the rule. All right, clerk will read the next bill.
Senate Bill 1026, Senator Bidel, Financial Institutions Consumer Credit Application of Licensing Requirements, Maryland Secondary Market Stability Act of 2025, favorable with one amendment.
Recognizing Chair of the Committee is the floor leader.
Thank you, Mr. President. Senate Bill 1026 is an emergency bill that was brought to me by the Commissioner of Finance that establishes Title 11 of the Financial Institution Article, which governs licensing requirements for various types of consumer lenders. Generally does not apply to a person that acquires or is assigned in whole or part to 1, a mortgage if the person does not otherwise make mortgages, 2, a mortgage loan if the person does not otherwise make mortgages or engage in the mortgage lending business, and 3, an installment loan if the person relies on another person to service or collect on the loan and does not otherwise make installment loans. The requirement does not apply to specified provisions of a law governing the sale of a loan account to an unlicensed person. The bill also establishes the Maryland Licensing Work Group to study and make recommendations on licensing requirements for persons that provide financial services in the state. The work group must report its recommendations by December 31st, 2025. Amendment 1 states that Section 1 of the Act is intended to clarify existing exemptions under law. I move the adoption and the favorable committee report.
All right, floor leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, recognize the senator from the 44th District.
Thank you very much. I had received and some of us may have also received the same document from Economic Action Maryland, so I had some concerns that I spoke with the floor leader on, and would hope that we can lay the bill over.
All right, the senator's motion is in order. The bill and the amendment will lay over under the rule. All right, clerk, read the next bill.
Senate Bill 1036, Senator Gazzone, Howard County Alcoholic Beverages Class D Licenses, Delivery, Howard County 2125, favorable.
Recognize the senator from the 12th District as the floor leader.
Senate Bill 1036 authorizes the holder of a Class D license or an employee of the license holder to deliver alcoholic beverages within Howard County in the same manner as the holder of a Class A license. There are no amendments. No fiscal impact, no opposition to the committee hearing. There was a letter of support from the Howard County delegation. Move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? I don't know. Okay. Lost it. Too many things flying. Too many things flying. All right. On the report, any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 1036 is hereby ordered printed for third reading. All right, let's go to Education, Energy, and the Environment. Calendar, report number 18. Clerk will read the first bill.
Senate Bill 308, Senator Simon Eyre, Election Law, Chief Election Judges, Party Affiliation, favorable with one amendment.
I recognize the bill sponsor, the floor leader.
Thank you, Mr. President. This consensus bill modifies provisions governing the party affiliation of chief election judges
and other judges assigned to a polling place. The bill requires at a polling place they have equal number of judges and election judges from the majority party and minority or principal minority party to the extent practical. However, if the election director designates 2 chief judges at a polling place and is unable to designate one from each party within 45 days, the election director must designate 1 chief judge from the majority party or principal minority party and 1 chief judge who is not registered with either party. There was 1 committee amendment that adds co-sponsors, no fiscal impact, passed unanimously. I move the adoption of the 1 committee amendment and the favorable committee report.
Floor leader moves the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Yes, recognize the senator from the 28th district.
Yeah, thank you, Mr. President. May I ask the floor leader
Will the floor leader yield
question
for a
or
question?
2?
Sure.
Senator may proceed.
Yeah, thank you, Mr. President. So what's the problem we're trying to solve with this bill?
Thank you for the question. So currently in law, we just say that the election judges have to be from both parties, equal. But it does not state that the chief judges have to be from different parties. So you could have 2 chief judges from the same party at 1 precinct. So this just basically says that you'll have 1 from each party.
Thank you.
All right. On the amendment, any discussion? Any objections? Without objection, the 1 committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 308 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 310, Senator Simon Ayer, Education, Youth Suicide Prevention School Program, revisions, favorable 1 amendment.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President. I know we get busy down here and we often don't get to see a glimpse into people's personal lives. And, you know, I've shared before on the floor that my dad and I would go out to Las Vegas once in a while and gamble and have a good time. But then when gambling came to his state, it became much more accessible, and he ended up gambling, lost $1 million, died broke a couple years ago. And I shared that, but also something I haven't shared is on my mother's side, my grandfather was into gambling, and he actually committed suicide because of the shame. So over the years, I've tried to bring legislation to bring awareness to gambling and the potential dangers. And I like a good game of blackjack, but I'm very careful how I proceed with the history in my family. But this interim, I worked with the stakeholders because we know we don't want to mandate curriculum. So I got everybody together, and this is consensus legislation, which I'm happy to move forward. So the bill expands the educational programs authorized under the Youth Suicide Prevention School Program to include classroom instruction designed to increase pupils' awareness of the relationship between gambling and youth suicide. The bill likewise expands findings and declarations in the General Assembly to include 1, youth suicide often exists in combination with other problems, including gambling addiction, and 2, that suicide prevention programs for young people must recognize student behavioral health issues, recognize students experience trauma and violence out of school, and refer students to health services. There was 1 amendment. It adopts clarifying language that suicide prevention should promote recognizing opposed to must recognize. There was no fiscal impact, no opposition. I would move the 1 committee amendment and the favorable report.
Floor leader moves for the adoption of the 1 committee amendment and the favorable report. On the amendment, any discussion? Any objections? Without objection, the 1 committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 310 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 318, Senator Lewis Young, Higher Education, Janet L. Hoffman Loan Assistance Repayment Program, eligibility, favorable with 2 amendments.
Recognize the senator from District 9 as the floor leader.
Thank you, Mr. President. Colleagues, as amended, this bill expands eligibility for the Janet L. Hoffman Loan Assistance Repayment Program to include veterinary practitioners and veterinary technicians who received a graduate, professional, or undergraduate degree from any accredited veterinary college or university. The recipients, veterinary practitioners, and technicians are subject to service commitment as an employee in the state for a period of no less than 5 years, or as a volunteer for a minimum of 100 hours per year at specified entities. There are 2 committee amendments. The first one adds a co-sponsor, and the second one corrects a drafting error by removing the expanded eligibility for veterinary professionals from under the Nancy Grasmick Public School Professional Award part of the program. I move the adoption of the 2 committee amendments and a favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 318 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 342, Senator Sidnor, Voting Rights Act of 2025, Counties and Municipalities. Favorable, 3 amendments.
Recognize the Senator for Prince George's as the floor there.
Thank you, Mr. President. This bill establishes a Voting Rights Act for counties and municipal corporations in the state by establishing a specified prohibition against the impairment of the ability of members of a protected class to elect candidates of their choice in elections in a county or municipality, or to influence the outcome of such elections. Includes factors, considerations, and criteria related to the establishment of a violation of the prohibition, and authorizes a person to bring an action to enforce the prohibition in the county or municipality where the alleged violation occurred. The bill does not apply to statewide elections. There are 3 committee amendments. The first is technical. The second one combines the requirement for counties and municipal corporations into a single subtitle, clarifies that a violation that may be established by a method of election that dilutes or abridges the voting strength of a protected class can be demonstrated by the existence of one or more methods of election that could be constitutionally adopted that would likely mitigate the dilution. It also provides that specified evidence may be considered by a court in determining whether a certain violation occurred, and authorizes the office of the Attorney General and any other person to bring an action to enforce the provisions of the Act. Amendment number 3 adds a severability clause. There is no fiscal impact. I move adoption of the 3 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 3 committee amendments and the favorable committee report. On the amendments, any discussion? Yes, sorry. Recognizing the minority leader on the amendments.
Thank you, Mr. President. The floor leader could yield for just a quick couple questions.
Sure.
Sir, may proceed.
Thank you very much. Can you just explain the current conditions and how this changes the conditions?
Right now, there is not a protection for this limited space of counties and municipalities that provides for these protected classes to have a remedy if there is found to have been a place where they have been disenfranchised. And so this is going to provide a new protection that is in keeping with the Voting Rights Act on the federal level in these elections.
So is this new protection have to do in how precinct or voting districts are drawn?
No, it is not prescriptive in that at all. It just talks about whether or not whatever method that a county or municipality has, that there is a process by which you can make your case, basically, that you as a group, like a specified group, have experienced some disenfranchisement in the process, and then it allows for a process that allows you to then to seek a remedy for that.
So what type of remedies could be available?
You would go to the Office of the Attorney General, who would then, they would seek a way to change, let's say you would have a certain format of an election. The example that was given to us was a situation where you've got a county-wide, you got districts in the county, but then those districts are elected by county-wide, but inside the district, you may or may not have had the number of voters that were in there that actually elected the person. That would be a sort of like a situation that would then say, okay, no, that there was some harm there. You all need to go back and create a fairer map or a fairer election, not a map,
not
Okay.
the map.
Well,
A
that's-
fair election.
That's what's getting concerning. We've had bills the last few years that have tried to dictate how counties
Yeah,
would
I
elect.
misspoke. It doesn't do that. It just says you then go back and, come up with something that's fair, not telling you what to do.
I'm sorry, when you said you go back, who's the you when you?
The entity that's generated the election, let's say a county or a municipality, because that's what these are associated with.
Okay,
I'm sorry, the you was a county or a municipality. Sorry.
Okay, so the attorney general would go to the county or municipality and say, you need to make some type of changes?
If there would be that determination, where they would be able to go and seek injunctive relief, which basically they would go to the court.
Okay.
But they would go through the attorney general, though. But they would go to the court.
Okay.
And the court's generally going to try to negotiate in that process.
Okay, all right. And I'm just trying to get again to what the solutions could be, because again, I refer back to a number of years we've seen legislation in that has tried to dictate how county commissioners are elected, especially in the rural counties where we have, let's say, the county that I represent has 5 districts.
Yes.
And there's a residency requirement, but each of those commissioners are elected on a county-wide basis. And there has been movement to try to change that through specific legislation. And my concern is this bill trying to address that type of situation.
This bill is not prescriptive to any form of election or anything else like that. This is dealing with a protected class and making sure that they're not being disenfranchised and that they have a remedy if that happens.
Right.
Excuse me. And there are standards in the bill that they would have to meet, like tests to meet, in order to be able to seek that relief.
Okay. But their complaint would be lodged with the Attorney General's office. The Attorney General's office would then require.
It would go to the court.
So Attorney General's out, or the Attorney General refers to the court?
The Attorney General can bring the case, or the individual can bring the case.
Okay.
So if someone were to go to the Attorney General because they're not sure of the situation, the Attorney General could take the case, but an individual could take the case as well.
To the local court?
Correct.
Okay. All right, thank you very much.
Sure.
But, Mr. President, can we just for further evaluation of this, the bill and the amendments lie over under the rule, please?
Senator's motion is in order. The bill and the amendment will lie over under the rule. Clerk, read the next bill.
Senate Bill 369, Senator Watson, Public Libraries Automated External Defibrillator Program, Romano A. Russell Act, favorable with 2 amendments.
Recognize the senator from the 23rd is the floor leader.
Thank you, Mr. Chairman. Colleagues, this bill is a result of a member of my community, postal worker, who stopped at a Crofton library and was found unresponsive after delivering some mail. And when the library assistant called 911, they were told to get the AED device, and there was none available. This bill requires each operator of a library, as defined in the bill, beginning January 1st, 2026, to place an automated external defibrillator, hereafter called AED, in a prominent area accessible to employees and library users, maintain its functionality, and ensure that an individual trained in the operation of the AED is present at any time the library is open. The library subject to the bill is excluded from the Maryland Public Access AED program. However, the library must register with the Maryland Institute for Emergency Medical Services Systems. The Maryland Department of Health and Medical Services System must jointly adopt specified regulations to implement the bill's requirements, and a specified report should be submitted to the House Economic Matters Committee by December 1st, 2026. There's two amendments. First is technical, adds co-sponsors. The second amendment generally requires the operator of a library with an AED to comply with the requirements of the AED administered by the Emergency Medical Services Board, EMS Board, and strikes the explicit staffing requirement, strikes correctional services libraries from the definition of library, strikes the Maryland Department of Health and adds the Education, Energy, and Environment Committee as the recipient of the report under the bill. There's minimal fiscal impact. I move adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 369 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 534, Senator Kagan, election law, election judges, compensation, favorable 2 amendments.
Recognizing the vice chair is the floor leader.
Thank you, Mr. President. Colleagues, in a bunch of our counties, we had problems with people signing up to be election judges. They took the training, and then they never showed up on Election Day. And this just says that if you take the training but you don't do the job that we're hiring you to do, we're not going to pay you. There are 2 amendments. The first is technical, and the second, which we started talking about, allowing, that's okay, the T will live. Sorry, thank you. Excuse me, thank you. Crap. The second amendment, just we were going to allow student judges to get both student service learning hours and pay. That was excised from the bill. So this is simply, we're not going to pay someone for a job they didn't do. Move the adoption of the 2 committee amendments and the unanimously passed favorable committee report.
All right. I was trying to think of some Boston Tea Party joke, and I couldn't come up with it. I couldn't get there. All right. 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 534 is hereby ordered printed for 3rd reading. As we are doing some dry up, we'll just buy some time for a minute before we read the next one. Yes, recognize the senator from District 12.
Can I do a quick introduction?
Senator may proceed.
All right. I want to welcome to the body another doctor of the day. We're blessed because we have 2 floor sessions. We have Dr. Jennifer Christie, who is the immediate past president of the American Society for Gastrointestinal Endoscopy for the last 2 years. She is visiting from the University of Colorado, where she's the division head of gastroenterology and hepatology. Just a renowned scientist, has over 100 peer-reviewed publications and many research articles and research that's going on, also named Atlanta's top doctors in 2021, 2022. So welcome here. Certainly glad to have you here in the state of Maryland as our doctor of the day today as well. Thank you so much. Warm
Welcome.
Senate welcome.
Welcome. Thanks for being with us. Thank you. Thanks for the great work. All right, clerk will read the next bill.
Senate Bill 645, Senator Kagan, election law, gubernatorial primary election date, favorable.
All right, recognize the vice chair as the floor leader.
Thank you, Mr. President. I just want to give a shout out to our pages. Not only did they distribute amendments and do all the things, they even help rescue tea spills. So thank you to you all. Our current law says that primary election day should be held the 4th Tuesday in June, but as you know, sometimes June has 5 Tuesdays. This bill just changes it from the last Tuesday to the 4th Tuesday. And the reason why that's important is because when school lets out, there are a lot of our school systems that immediately want to pop into school renovation, school repair. The community centers might have started their summer programs by then. Families may have already left on vacations, summer vacations, and so it is there are fewer locations for early voting sites, and that's a problem. There are fewer judges that are available to work because they might be traveling, and so this is just common sense, moving it from the last Tuesday in June to the 4th Tuesday in June, which would apply, Mr. President, to next year's election. So there are no committee amendments. Move adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Recognizing the senator from District 7 on the report.
Just a quick question.
Floor to yield. Senator may proceed.
So how does this deal with snow days, and if a school system has to push the school system back a few days getting into later in June?
Thank you for the question.
You're
We are
very
still
welcome.
good because schools are not that close to the election day, but we want to make sure that early voting and stuff can start a little earlier while students and their families are still in town. We also were a little bit concerned about early voting, people needing to work as judges on Father's Day or on Juneteenth. They might want to do other activities. And so again, by shifting it, we help avoid that as well.
So that, I guess what I'm doing math in my head, what would make it? The earliest would be the what? June 28th? What? 20? What is the, so the earliest it could be is the 22nd, and the latest would be the 28th. And most schools get out what now? With the 15th? Okay. So, okay. So good question. Early voting. What's this push early voting up now by a week?
Early voting would also move up a week.
Okay.
Thank you.
All right. On the report, any further discussion? Any objections? Without objection, the favorable committee report is adopted. Any amendments to the bill or its title? Seeing none, Senate Bill 645 is hereby ordered printed for third reading. Let's go to, stay with the Committee on Education, Energy, and the Environment, Report 19. Clerk will read the first bill.
Senate Bill 309, Senator Simonaire, Department of Veterans and Military Families, Online Registry, favorable 2 amendments.
Recognize the bill sponsor as the floor leader.
Thank you. No personal stories. This bill requires a communications outreach and advocacy program in the Department of Veterans and Military Families to establish and maintain an online registry to provide information to registered individuals. The Secretary must also include in their annual report specified information relating to the registry. The bill also alters several definitions. There were 2 amendments. The first one was technical. The second one removes the requirement for the registry but adds additional reporting and other requirements to the communications outreach and advocacy program to assist service members with accessing benefits, adds service members to the provisions of the bill, and otherwise conforms the bill to the language of the Omnibus 275. There were no fiscal impact, passed unanimously, and I move the adoption of the favorable committee report and amendment.
Floor leader moves the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 309 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 491, Senator Guile, General Provisions, Veterans Benefits, Honorable Discharge, favorable 2 amendments.
Recognizing Senator from Anne Arundel as the floor leader.
Thank you. As amended, this bill simply authorized the Department of Veterans and Military Families to allow benefits to be awarded if the department determines that the benefits should be allowed based on specific provisions in federal law that govern authorizations of changes for eligible benefits related to discharge status. There were 2 amendments. The first is technical and adds co-sponsors. The second amendment strikes the provision of the bill and authorizes the department to allow benefits to be awarded if the department determines the benefits should be allowed based on specific provisions in federal law. There's no fiscal impact. I move the favorable committee report and amendments.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 491 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 555, Chair, Education, Energy, and the Environment Committee, Public Information Act, denials pending litigation, favorable with 1 amendment.
Recognizing Chair of the committee is the floor leader.
Thank you, Mr. President. As you all know, we've got the Maryland Public Information Act, which establishes that we're all entitled to have access to information about the affairs of government and the official acts of public officials and employees. There are certain privileged documents that don't have to be turned over, et cetera, but Senate Bill 555 is a bill from the Attorney General that addresses a growing problem or loophole of sorts, Mr. President. The problem is twofold. First of all, it arises when the government, state of Maryland, a county, is a litigant in a pending litigation or about to get involved in anticipated litigation. And the opposing party litigant uses the PIA application process to get sensitive information that was created by the government agency for the very specific purpose of the litigation or in anticipation of the litigation, rather than going through the normal discovery process, which is how parties normally get information relevant to a lawsuit. The government does not have that ability to get information from the private party opposing litigant, so it does give the other litigant an advantage over the government. Another related problem, Mr. President, it becomes a tool where the opposing litigant uses the PIA request to disrupt the government's litigation efforts by inundating government lawyers with broad PIA requests designed to disrupt the work of the attorney assigned to the litigation. And so what Senate Bill 555 does, it borrows from provisions in many other states that addresses this loophole by allowing, not requiring, a custodian of the record to withhold certain records created specifically because of a pending or anticipated litigation. I would note, Mr. President, we have exemptions. This is very consistent with the spirit of the Maryland Open Meetings Act, where currently it permits bodies to close meetings to consult with staff about pending or potential litigation. It does not preclude litigants or potential litigants from obtaining underlying documents that pre-existed the anticipation of litigation created in the ordinary course of business that might become relevant evidence in the litigation itself. It's limited to records specifically created for purposes of the pending or anticipated litigation, and it does not apply to a record pertaining to litigation that has finally been adjudicated or otherwise settled. There was one amendment, Mr. President, when the bill came in as introduced. The language was pretty broad, vague. I would say it did not define reasonable anticipated litigation. The committee put an amendment to define it as a situation where there is concrete evidence that litigation is expected to occur based on current facts and circumstances. Mr. President, with that, I'd move the favorable committee report, that one committee amendment, and certainly we'll take questions.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report, recognizing the minority whip on the amendment.
Thank you, Mr. President. I wonder if my friend the chair would yield.
Senator may proceed.
Yes, sir.
Thank you. So this was sort of a interesting committee vote on this, kind of a diverse group of folks for and against. So, and as I look at the bill, I guess I'm a little, obviously there's concerns in the file from a number of organizations, the Maryland DC Press Association and the ACLU and some other groups that even MCASA weighed in against the bill. And do the amendments remove sort of all objections or some, or how does the amendment remove the objections?
Absolutely. So I think the primary objection, I think the lead opponent as the bill came in as introduced was the Press Association. Mm-hmm. And they really thought that the language was, again, overbroad and vague when it talked about reasonably and litigation. And so what the committee did with the amendment, and I can't say that all those groups necessarily pulled the opposition. I can say that I did get an email, and it was represented, although they do not necessarily love the bill, that I'm going to quote, this is in the amendment, they can live with the amendments. So I think they've come from a position of opposition that the bill was overly broad in that very specific provision to now with these tighter amendment. They don't love the bill, but if we're going to pass it, that they can live with the version of the bill as amended.
I guess I'm trying to understand the problem that we're trying to solve. Now, you explained well that if when an agency gets a Public Information Act request that is extensive, it takes a while for attorneys. I assume it's the AG's people at that agency that have to fulfill the request?
Well, just to be clear, this will extend not just to a matter that the state of Maryland is a litigant, but this will extend both to counties, municipalities. So you'll see that MML, MACO, this is a bill from the Attorney General, are all very favorable about this. So this is not just about AG in the state of Maryland. This extends to Carroll County lawyers, to MACO, to MML, et cetera, et cetera, et cetera.
Well, I understand that. And my point in talking about the AG was not about the Attorney General himself or even the central office, but isn't it true that if an agency receives a FOIA request or a PIA request, like say MDE or DNR or any agency, is it the AG's folks there that fulfill this request? I'm just curious about the process.
Yeah, let me walk you through that. That's an excellent question. So, yeah. Yeah, so I think typically a custodian is officially appointed by each agency, and usually it's a staffer.
Okay.
And they're assigned to go review it to see if there's, for example, attorney-client privileged, sensitive health, financial information that may be protected. There's a body of law that says when you ask for information, you don't necessarily get it all. And so there is a scrutiny. There is a process. There's an actual board in place. Specifically the I forget the name of the board. They can resolve a dispute. So let's say the agency does give documents or withholds documents that are it would be in violation of federal law or state law. There's a process whereby the applicant can file a complaint, and it goes to a board, a PIA board, to resolve the complaint, try to mediate it. And if that fails, you can then go to circuit court and actually litigate whether what was held was appropriate. So there is a process starting with staff and this custodian of the record that does that initial vetting. If there's a dispute, it goes to this board to try to resolve it. And if that fails, then there's always a remedy to go to circuit court.
So if that process can take place now, this is going to say that there are more records that are not available for this kind of scrutiny because and with the amendments, they
right, so you're either in the middle of the litigation.
That is expected to occur?
Correct. Specifically, if you look at the amendment, again, we tightened the language as it came up was, I would just say it was vague, and so this new language is you're either in the middle of a pending litigation where a PIA request is trying to get information that, many cases would be protected by attorney-client privilege, but there's some gaps. Or it's the language now would say it defines reasonable anticipated litigation as a situation where there is concrete evidence that litigation is expected to occur based on current facts and circumstances. But just to be clear, the documents that are the subject of this bill is very specific. It's limited to records specifically created for purposes of the pending or anticipated litigation. So, you're in a lawyer in the government, and you're working and producing documents as part of the litigation or about, and the opposing litigant's not going through normal discovery, but using this PIA process to basically get a bunch of stuff or inundate the government lawyers with overbroad. So that is a problem. And
yeah, I can understand that, and I look at it a little more closely. But what is there? And it is the amendments do tighten it because it was very broad to begin with. But aren't we saying that now you're even having members of the press or others that can't get access to, even with the tightness of this, created for the purposes of pending and reasonably anticipated litigation? Anticipated is different than actual litigation. Now, sometimes I guess I can understand that there's a time there's going to be a lawsuit over something, but this could even be construed as, well, we just approved a new development in this community, and we expect that someone's going to sue us. So we can't release any information about any emails about how decisions were argued back and forth, or how can we avoid that kind of thing from being the outcome of this bill, I guess is my question.
Well, I think the language is, I think it's targeted. I think that, what the Attorney General's office came and said, this is a problem, putting the state of Maryland or Carroll County or one of your municipalities at a huge disadvantage in trying to, normally you get evidence through discovery, and this is essentially a loophole. You're circumventing the normal litigation process of obtaining relevant information and inundating the government attorneys with super broad requests and hoping that maybe something will fall through the cracks, or just using that process in lieu of and it doesn't have to be the litigant. It could be somebody who's sort of sympathetic to the litigant, who jams in there and tries to get some information that they could then share with the litigant that's trying to sue the state of Maryland or Carroll County or someplace like that. So the Attorney General wouldn't have come to the legislature with this piece of legislation unless they thought, or he thought, that this was a growing problem for our state. And our counties and our municipalities.
So I'm less concerned with restricting people who are involved in the litigation, because I agree with you. You don't want phony discovery. You don't want that. Your point about the sympathetic litigation, somebody sympathetic, well, that's, again, it's a broad category. Let me just say this. The Attorney General has found a lot of problems to come to the General Assembly, that could happen to come to the General Assembly. There's been a lot of bills. So let me do this. Let me ask well, it's an automatic request, I guess. Mr. President.
Senators, just if we could please.
I won't belabor it anymore. I'd like to look at this a little closer. Let me ask the bill and the amendment lie over under the rule.
That's fine.
Senator's motion is in order. The bill and the amendment will lie over under the rule. Let's see. Do we have another one? Clerk will read the next bill.
Senate Bill 871, Senator Hester, Department of the Environment, Community Water and Sewage Systems, Cybersecurity Planning and Assessment, favorable with 2 amendments.
See the bill sponsor, Senator from District 9, recognized as the floor leader.
Thank you, colleagues. This is a great bill. I don't know how many of you often think about the safety of your water, but I learned recently that 9% of public water systems were critically or highly vulnerable to cyber attacks. These cyber attacks can lead to contaminated drinking water, disrupting services, endangering public health, and widespread economic losses. So what does Senate Bill 871 do? This bill establishes various requirements for the Department of the Environment, the Department of IT, the Department of Emergency Management, and our community water system and community sewerage system providers related to the planning and preparing for cybersecurity attacks on the wastewater sector. There are 2 amendments. The first amendment is technical. The second amendment alters some of the requirements for the agencies and the community water systems and require MDE to report on water system compliance. It strikes requirements for a tabletop exercise and makes other clarifying changes. The bill has a limited fiscal note requiring only 1 PIN for Do-It to assist MDE in the provisions of the bill, and it passed our committee unanimously. I just also wanted to thank somebody. We had the equivalent of a 1-star general come down, Mr. John Garska, to testify, and he's committed to providing a lot of technical expertise and a subject matter expert for the state. And so with that, colleagues, I would urge a favorable report on this unanimously passed bill.
All right. Floor Leader moves the adoption of 2 committee amendments and the favorable committee report. Was also very pleased to spend some time with him. He was very knowledgeable and was very great. It's excellent. All right. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 871 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 968, Howard County Senators, Howard County, Patuxent River Wildland, Use of Motor Vehicles and Motorized Equipment, Howard County 525, favorable 2 amendments.
Recognizing the senator from Howard County as the floor leader.
Thank you, Mr. President. Colleagues, this is a local bill. It has to do with the Patuxent Wildlands and the ability for our emergency responders to get in there in case of an emergency. As amended, the Senate bill authorizes the Department of Natural Resources to use mechanized and motorized equipment within the Patuxent River Wildlands for the limited purposes of maintaining and removing or replacing existing trails or removing, replacing, and disposing of non-native species. There are 2 committee amendments. The first one is technical, and the second one strikes some language that would have authorized the department to enter into user agreements with volunteers. There is no fiscal note, and I urge the adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 968 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 1028, Senator Guile, Natural Resources Vessels, Carbon Monoxide Warning Labels, favorable with 2 amendments.
Recognizing the Vice Chair as the floor leader.
Thank you, Mr. President. Matthew McHale, the name might sound familiar. He was a young man who in 2016 died of carbon monoxide poisoning on a sailboat. In a boat. And our former colleague and friend, Senator Riley, brought legislation in his memory several times, and his fabulous successor from District 33 has continued, and we are now bringing this bill in memory of Matthew. Working with the Department of Natural Resources and others, this simply requires warning stickers on a boat, on the transom and the two parts of the transom and the helm. The transom is the rear, the helm is the steering area, warning people about carbon monoxide poisoning. 400 Americans roughly die from carbon monoxide poisoning every year because it is a colorless, odorless, tasteless gas, and sometimes that's mistaken for seasickness or being drunk or something intoxicated. And so we want to make sure that we can try to protect Maryland boaters from this tragic death, and his family has been active on this issue for many years. And so there are two amendments, technical and clarifying. I'd like to move adoption of the committee amendments and the favorable committee report.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question, excuse me, I'm sorry. Please strike that. On the amendments, recognizing the senator from the 29th on the amendments.
Thank you, Mr. President. If the floor leader would yield.
Senator may proceed.
Of course.
We'd just like to know what description we're using on a vessel.
Thank you for asking the question. Actually, one of our really smart members of our committee asked about the bill as it came in, talked about gasoline powered, and that was actually not precise enough because he pointed out that some boats are powered by diesel. So that was clarified. It's also not all boats, it's just those since 2007. So it is clarified and narrower, but also more inclusive of any boat where somebody could be vulnerable to carbon monoxide poisoning.
So would this cover an 8-foot open boat that had a 1 horsepower motor on it?
I think I might yield to the sponsor of the bill with boating questions because I suspect she's got more expertise on that than I do.
Recognizing the sponsor of the bill.
Thank you very much, Mr. President. I wish I had more expertise on, but I can say, in looking at the fiscal note, it says vessel is, as it applies to the State Boat Act, to which the bill's provision is added, means any description of watercraft, including an ice boat, but not including a seaplane that is used or capable of being used as a means of transportation on water or ice. It includes the motor, spars, sails, and accessories of a vessel.
So, thank you. I'd just like to say that having investigated people that got sick and died with carbon monoxide, it usually always related to a cabin or a area that the fumes could have been contained. A simple open boat like a Zodiac or something like that under the State Boat Act, every boat would be included. And so we have certain regulations under the State Boat Act that require when you, in fact, would have a be able to use a fire extinguisher and have a fire extinguisher on board because there are certain areas that could contain fumes, right? And so, Mr. President, if I could ask that the bill lay over under the rule for the purpose of an amendment.
Senator's motion is in order. The bill and the amendment will lie over under the rule. Clerk, read the next bill. That was it on that one. All right. Almost there with Triple E. Been working hard. Report number 21. Clerk will read the first bill.
Senate Bill 175, Senator Lewis Young, Public Safety, congruated stainless steel tubing for fuel gas piping systems, requirements, and prohibition. Favorable with two amendments.
Recognizing Chair of the Committee is the floor leader.
Thank you, Mr. President. This bill was substantially amended, this important public safety bill. As amended, the bill prohibits the sale of non-conductive jacketed corrugated stainless steel tubing. A violation of the provision is a civil penalty up to $1,000. In addition, the amended bill requires the Department of Labor, in collaboration with the State Fire Prevention Commission and the Fire Marshal, to study the prevention of fire hazards associated with corrugated stainless steel tubing. The bill takes effect June 1, 2025. Mr. President, there are two amendments. The first one is technical. The second bill amendment alters the bill as described. I'd move the adoption of the two committee amendments. Oh, well, actually, I'm
No.
sorry.
Question, all right.
Will the chair yield?
Well, the
please?
senator moves for the adoption of
Okay,
the two
actually,
committee amendments.
We don't want to adopt the committee amendments
Okay,
yet,
okay.
Mr. President.
Yeah, okay, I stand corrected. What we do want to do is, because the sponsor of the bill has some amendments that I'd like to take back to the committee during the between sessions to discuss, and thank you for catching me before I did that, because we want to take that up. So we'd like to move to special order of the bill till the second session today, so we can take up and discuss the sponsor amendments, okay?
Special order?
Special order till the
Okay.
second
Senator
session
wishes
today.
to, move to special order. Any discussion or any objections to the senator's motion to special order? Without objection, the motion carries. The bill will be special ordered to the appropriate time to the session, the evening session. Let's call it the evening session. We may have two sessions this morning, so the evening session. All right. Clerk, read the next bill.
Senate Bill 250, Chair, Education, Energy, and the Environment, Department of Environment Fees, Penalties, Funding, and Regulation. Favorable 3 amendments.
Recognizing Senator from District 9 as the floor leader.
Thank you, Mr. President. This departmental bill makes various changes to the Maryland Department of the Environment's regulatory authority, the special funds it uses to carry out its statutory duties, and the fees that generate revenues for those special funds. The bill also alters and enhances the state's regulatory framework governing dams and establishes a related special fund to provide financial assistance for the repair, upgrade, or removal of private dams deemed to be in an unsafe condition by the department. There are 3 committee amendments. The first is technical. The second strikes provisions of the bills that would have altered fees under the Erosion and Sediment Control Response Personnel Training Program and the Wetlands and Waterways Program. The amendment also expands the purposes for which the Maryland Clean Air Fund may be used, alters the committees to which a certain annual report must be submitted, and restores a certain condition on the issuance of an oil transfer license. Amendment number 3 alters provisions of the bill related to dam safety to, among other things, exempt small, low-hazard dams from certain permit and registration requirements, delay implementation of certain dam registration requirements, and establish a hardship waiver for certain dam registration fees. The amendments also strike provisions of the bill that would have altered fees under the Lead Rental Registry, Voluntary Cleanup Program, and the Maryland Mining Program. I would move the committee amendments and encourage a favorable committee report.
All right, the floor leader moves to the adoption of the 3 committee amendments and the favorable committee report. On the amendments, recognize the minority leader.
Thank you, Mr. President. The floor leader would yield for questions, please.
Floor leader yield. Senator may proceed.
Thank you very much. Just going through the amendments, there were 2 programs that were amended out that you mentioned, the erosion and the wetlands and waterways. They were amended out. It looks like maybe 3 or 4 special funds have remained in the bill. Is that about right?
It's either 4 or 5.
4 or
Hold on.
5?
1,
Okay.
2, 3, 4, 5.
5. Okay, thank you. The first one the bill goes through is the Clean Air Fund, and it looks like that changes the fee from $50 to $200 per ton of regulated emissions. Who generally pays that that fee?
Who generally pays that fee? While we're looking for actually who pays that fee, I just might mention that all states have corresponding versions of this fee, and the Federal Clean Air Act requires all states to charge sufficient fees to cover Title V permit programs delegated to the state. So Maryland has to raise its fees to meet the federal requirement. Other states, such as Pennsylvania and Virginia, have higher fees for this permitted Title V facilities.
Okay, so those Title V facilities are what? Are they manufacturing facilities? Are they energy generating facilities? Are they gas stations? What are those types of fees or types of businesses?
We're looking that up right now, Senator. Do you have more questions?
Yes.
Okay, we'll get back to you on this one.
Okay, thank you. The bill as now brought in also changes it again from $50 to $200, but now is also tied to the CPI for automatic adjustments. Is that accurate?
That is correct, and the industry that we're still trying to define did weigh in support of this increase.
Okay, that's right. So I'm still.
I think probably the increase will enable the permits to go faster, and that is more important to them than paying the fee.
Well, that's what I was going to ask when we then started getting in. What is the difference, or what are we looking at per ton of regulated emissions? So is this going from again, I'm assuming it's more than 1 ton, but I don't know. Again, I'm trying to understand the volume of what this fee would be to a business.
Well, I think the volume varies a lot by the business.
Right.
The fee is going from 50 to not more than 200, and in Pennsylvania, it's much higher. In Pennsylvania, colleagues, it's $2,000 to $8,000 per year.
Per year or per ton?
Per year.
Okay, because this says per ton, right?
Right. So Maryland, their estimate from the department is that it will be 500 to 5,000 in Maryland. So that is per year.
Okay.
Virginia is, I'm trying to figure out. Do we have the other answer yet?
I'm going to ask to eventually. So let me just ask another couple quick questions, and maybe we can get some answers. I did notice a very interesting amendment with respect to this. It says, money deposited into the fund is not subject to Section 302 of the State Finance and Procurement Article and may not revert to the general fund of the state.
Well, once again, that is helping us to maintain compliance with federal regulations. If we kept that cap in there of $2 million and then we reverted it to the general fund, we run the risk of not having enough money in the fund to actually meet our federal regulations.
No, I like the amendment. I would think that we should probably see if we can put that on more of the funds that we have. I mean, right now, program open space and the land conservation are under attack. The Strategic Energy and Investment Fund is under attack. Maybe we should use that amendment on more of these special funds that are out there. So that is appreciated. Finally, there was one more part about the potential that MDE withdraws the authority from a county health officer, or the health officer returns that authority with respect to on-site sewage disposals and well construction permits. That's more of a policy change or potential than just the fees. I know that the bill itself allows the department to then collect the fees if that change was made, but
that is a policy change, and it's actually
Right.
something I've dug into over the past couple of years. What we're experiencing at the county level is a lack of staff. And so what this would allow is, right, they already have the ability to take over, like the state can take it back from the local authority because we delegate it to them.
Right.
But if the state takes it back, then they need the ability to charge a permit fee, just like the county was charging a permit fee. And it's my understanding that the permit fee that is in the bill is similar to the county fees, which of course varied, but across the state.
Right, and again, I understand that part of it. I'm more concerned with the policy aspect of it and wondered, did MDE come in and talk about that potential policy change? Because
we've been talking about this policy change for the last couple years because literally we do not have the staff in some counties. And it's optional, right? But currently, as it stands now, the Department of the Environment has delegated authority to all the local counties. And we gave the counties the right to give it back to MDE, right. So if they so wish.
Right, so that's what I'm asking. So the counties can give it back,
right.
But does this allow a different policy change that allows the department to go in and withdraw that and take that? Or is that the condition that's always in place?
No, that's the condition that's always in place.
So currently, the county, the department can bring that back and say they want to handle it within the department, or the county can also say we don't want to do it anymore and give it back to.
Yeah,
that's current law?
That is current law. The current law is that the state delegates to the local health departments. The problem we're seeing is that local health departments don't have the staff everywhere to get this done. And so they're asking to give it back to the state. When the state takes it back, it needs to be able to charge for the permits, and the cost is almost equivalent to what the counties would have been charging previously.
Okay, I just want to make sure that that's not a different policy change. Again, I understand why it's in the bill if it's related specifically to having the Department of Environment now collect the fee, but I just want to make sure that this is not a policy change, because while you say, you know, certain counties may not have the ability to handle that, I know also from certain counties, the Department of Environment has made, is getting different types of ways that they are now analyzing, especially wells and on-site sewage, that is making it much more difficult for counties to release some of those permits. And as there's been many discussions going on about housing, and
That is not in this bill.
that's not what we're trying to do.
That is not in this bill.
So, okay. All right, thank you very much, Madam Floor Leader. Mr. President, I know we were going to get some other answers, so.
I do have an amendment.
Not quite yet.
Okay.
So if the bill and the amendments can lie over under the rule.
Senator's motion is in order. The bill and the amendments will lie over under the rule. All right, let's see. Clerk will read the next bill. Right.
Senate Bill 456, Senator McKay, Dental Services, Qualification for Maryland Dent Care Program, and Study on Use of Dental Online Credentialing. Favorable with 2 amendments.
Oh, yeah, recognize the senator from the 38th District as the floor leader.
Thank you, Mr. President. Senate Bill 456 is an important bill, especially for our rural areas. We're all facing healthcare access issues and shortage of providers. And this bill, as amended, expands eligibility for the Maryland Dent Care Program to include dentists and dental hygienists employed on a part-time basis. The bill also requires the Maryland Higher Education Commission, MHEC, Office of Student Financial Assistance, in collaboration with the Maryland Department of Health, to establish prorated loan repayment assistance for any part-time dentists and dental hygienists participating in the program. There are 2 committee amendments. One is technical. The other strikes a requirement that the Maryland Insurance Administration conduct a specified study. I move adoption of the 2 committee amendments and the favorable committee report for SB 456.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report on the amendments. Any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 456 is hereby ordered and printed for 3rd reading. Clerk, read the next bill.
Senate Bill 543, Senator Kagan, Election Law, Provisional Ballots, Nonpartisan Board of Education Contest. Favorable.
Recognizing the Vice Chair, bill sponsors, the floor leader.
Thank you, Mr. President. Colleagues, sometimes I use visual aids, and this is one of those bills where I'm doing that. So, if you vote a ballot...
Senator, that is not permitted. Not permitted.
None at all.
No,
but
no
it's not
visual
advocacy.
aids.
Okay.
No visual aids.
Well, then I'm just going to explain that when you vote a ballot in the right place with the right party in a primary, whether it's Democratic, Republican, or unaffiliated, your ballot is reviewed, scanned, and tabulated. Sometimes voters show up at the wrong location, and they might show up outside their legislative district, let's say, someplace more convenient to them for their workspace or something. They show up and they insist on voting there, and that ballot is not going to be fully counted, but their race, if they're in the state of Maryland or within their county, their ballots for governor, for county executive, for sheriff might be fine. Those will all be duplicated and counted, but they might be outside their legislative district. So their votes for state senate or for state delegate would not be counted. Here's what this bill does. Sometimes people show up and they insist on voting outside their party affiliation. They're a Democrat and they want to vote in the Republican primary, or they're Republican and want to vote as a Democrat, or they're unaffiliated and they want to vote in a partisan primary. Maryland has closed primaries, and so if they are given the ballot for which they are not eligible, today most counties throw the whole ballot away. This would, in keeping with practice in some counties, would allow, regardless of which party they are or are not affiliated with, would allow their ballot for school board to be duplicated and counted. There are no committee amendments. It passed unanimously. I hope that was clear, but I am happy to take questions without any visual aids and move adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. The rule was recently invoked on a Mylar balloon turtle, and so hence, yes. All right, on the report, any discussion? Any object? Yes, Senator from the 37th District has a question on the report.
Thank you, Mr. President. Just a quick question.
Senator, may proceed.
So how would this situation occur? You would receive the incorrect ballot, and then...
So, thank you for the question, Senator. So if you're voting by mail, they're sending you the right ballot based on your party affiliation, your location, so that's not an issue. But if you show up on election day, or if you show up on election day at the or during early voting, and sometimes people really are there because they want to vote for or against a particular candidate. And so they may not be of that party, or as I said, they might be unaffiliated, but darn it, I really want to vote for or against this candidate. And election judges generally are told, don't argue with the voter. So kind of the customer's always right. So they are given the ballot. They are told that it is provisional. They are told generally that it will not be accepted. So if they are a registered Republican and they say, I want a Democratic ballot, they're not allowed to vote a Democratic ballot. This bill, though, would take that ballot from the provisional pile, which would otherwise be fully rejected, and allow them to vote for the one thing that they would be eligible for, which is the Board of Education, because it's nonpartisan. So whether you are Republican, Democratic, or unaffiliated, you are eligible to vote in a primary election for the nonpartisan school board.
Yeah, but when you go in to vote, don't you'll say, you know, Johnny Doe or whatever. I'll just use a fake name. I don't think I'll fake it too well, but you know, I am so and so. This is my address, and this is my party.
Yes.
So and then there's the judges would verify that information.
Correct.
And then they would hand the ballot to the voter, and the voter would go vote.
That is usually the way that happens.
And so either the judge has made given the wrong ballot to the voter, either that's happened, or the voter has demanded the wrong ballot.
The latter. That has happened. And I can say that in Montgomery County in 2024, it happened about 700 times, which is a lot, but you know, not tens of thousands, but it's a lot of people who insist on voting other than how they are registered from a partisan perspective.
Right. So they're making the conscientious decision to vote the wrong ballot, and then we're saying, well, they voted the wrong ballot. We're going to correct it anyway.
No.
Right.
So they are consciously voting, asking to vote for something they are informed they're not eligible to vote for. So they are voting in the wrong party lane. Currently, in most counties, the whole ballot is thrown out because they're not eligible. It's first put in the provisional ballot pile. Every provisional ballot is reviewed one by one by the local boards of elections. And in this case, if they voted the wrong party ballot, and I'm using wrong in air quotes, obviously, whatever party, but it's how you're registered. If they are insisting on voting a ballot that is not the one they are eligible to vote for, rather than throwing out the entire ballot, their preference, voter intent for just the Board of Education, which they were eligible to vote for, would be allowed and counted.
Thank you. I just wanted to understand the scenario by which
Absolutely.
This occurs.
It's a little confusing. That's why the visual aids would have been helpful, but I'm happy to show you offline afterwards.
All right, on the favorable report, any further discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 543 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 717, Senator Carrozza, Somerset County, salaries of local officials increase, favorable.
Recognize the senator from the 38th as the floor leader.
Thank you, Mr. President. Senate Bill 717 is a local Somerset County bill. It increases the salaries of certain public officials in Somerset County. Pursuant to constitutional requirements, the salary increases take effect at the beginning of the next terms of office. It's an important local bill to allow Somerset County to be on par with other counties. There are no committee amendments. I move for adoption of a favorable committee report for Senate Bill 717.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 717 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 770, Senator Guile, applicants for positions involving direct contact with minors, required information, review process, and reporting, alterations, favorable with 3 amendments.
All right, let's see. We've got the direct contact. Senate Bill 770. 770. Senator from the 30. Going once, going twice. So we're going to special order this one. All right, let's see if we maybe special order to Senator from the 23rd. All right, why don't we special order it for 5 minutes? Chair of the committee moves a special order for.
Yeah,
okay.
we moved to
We're moving.
special
As
order.
we're,
Well,
here we go.
actually, maybe not. We do have
Okay.
a gentleman who
Pull
I
back the,
believe maybe
I was going to give
timing
the
perfect.
As the good senator is looking for the floor report, there was a.
Is that you? I'm not.
Nope. Okay.
Okay, we'll special order for 5 minutes, and we'll
Okay.
figure what's going on here. Okay.
All right. Bill will be special ordered to the appropriate time in 5 minutes. That's not quite it. I'm getting there. All right. That one does it for that calendar. Let's go to.
Mr. President?
Yes, recognize senator from the 27th.
I'd like to reconsider a vote by which a bill passed second reader.
All
Is
right.
this appropriate time?
We can do it between calendars. Which report was the bill on, or do we have?
I have the bill number.
Can we get the bill number, and then we'll see if we have it out
Yes,
here?
Senate Bill 544.
544. Give us just a minute. Senator, after the next calendar, let's check. The secretary's going to make sure that we have it out here for the floor.
Yes, sir. For the
544?
544.
Okay. We'll go through the next calendar, and then we'll do it after that one.
Thank you.
All right. Let's go to budget and tax, report number 10. Clerk will read the first bill.
Senate Bill 396, Senator McKay, Public Safety Officer, Performance of Duties, Death and Disability Benefits, favorable with 2 amendments.
Senate Bill, let's see, 396. I recognize Senator from St. Mary's as the floor leader.
Thank you, Mr. President. Senate Bill 396, as amended, makes local 911 specialists eligible for public safety death benefits and requires that the state pay public safety death benefits to the surviving family of specified public safety personnel who commit suicide related to a diagnosed job-related PTSD and other stress-related disorders. There are 2 amendments. The first is technical. The second preserves the authority of the Secretary of Public Safety to award death benefits on a case-by-case basis when the individual intended their death, strikes provisions related to disability benefits, and strikes provision authorizing 911 specialists to enroll in the law enforcement officers' pension system. It also adds co-sponsors. I move the adoption of the committee report.
Yeah. All right, floor leader moves to the adoption of the 2 committee amendments in the favorable committee report. On the amendments, any discussion? Yes, recognize the vice chair of Senator from Montgomery County on
Thank
the
you.
amendments.
Will the floor leader yield?
Yes.
This is very exciting, and I know the senator from the shore and I have been working for 911 specialists. We have a work group and all that. I know this is a great bill. I wonder if we can just lay it over to the afternoon session so she and I can just chat with you super briefly. Thank you, Mr. President.
All right, on the amendments, any further discussion? Any objections? Oh, I'm sorry. I was trying to find that other bill. The question was layover. The senator's motion is in order. Bill and the amendment will lay over under the rule. Clerk, read the next bill.
Senate Bill 457, Senator Jackson, State Retirement and Pension Systems, transfer between systems work group, favorable with one amendment.
Recognizing the senator from District 11 is the floor leader.
Thank you very much, Mr. President. Senate Bill 457 is a Joint Committee on Pensions bill, and it requires the State Retirement Agency to convene and staff a work group of stakeholders to study the requirements and processes for transfers of member service between state and local retirement and pension systems, to make recommendations to improve that process. By December 1, 2025, the work group has to report its findings and recommendations to the Governor and General Assembly. There's one amendment, and the amendment just adds representatives from Anne Arundel and Frederick counties to the work group. I move for the adoption of the amendment and the committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 457 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 488, Senator Jennings, Manufacturer Business Personal Property Tax Exemption, favorable two amendments.
Recognize the bill sponsor is the floor leader.
Thank you, Mr. President. This is a economic development bill for small municipalities or small businesses in municipalities. The idea is trying to get small businesses to move into municipalities and grow. As the bill originally came in, it was kind of for all businesses. This one amended takes it down to smaller businesses under 50 employees. And what it does is authorizes local governments to exempt property tax for personal property for manufacturing businesses that have 50 or fewer employees, and that includes their inventory. And again, it authorizes, it's not mandating it. It's up to the actual municipality. There are two amendments. One is technical, and the second one basically strikes the provisions of the original bill and supplements with what I explained what the bill does. I move adoption of the committee report and the amendments.
Floor leader moves for the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 488 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 612, Senator Jackson, State Retirement and Pension Systems, deferred vested former members, returned to service, favorable with two amendments.
Recognize the senator from District 11 is the floor leader.
Thank you very much, Mr. President. Senate Bill 612, as amended, it's also a Joint Committee on Pensions bill that would allow certain members of the state police retirement system, the correctional officers retirement system, and law enforcement officers pension system who were members on or before June 30th, 2011 and had a specified break in service and returned to service after that date to be subject to the same benefits as a member who did not have a break in service. There are two amendments. The first makes technical changes to the title. The second strikes the provisions related to the non-contributory and contributory tiers in the employees' pension system for further interim review. Move adoption of the amendments and favorable committee report.
Floor leader moves for the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 692 is hereby ordered. Is that right? Not 612? 612 is ordered printed for third reader. Oh, it just went ahead one. It was 612. Okay, so let's just make sure. We have the amendments have been adopted. The amended report has been adopted. Any amendments to Senate Bill 612? If not, it is now ordered printed for third reader. Clerk, read the next bill.
Senate Bill 692, Senator M. Jackson, State Retirement Pension Systems, alterations and clarifications. Oh my goodness.
Recognizing the senator from District 11 is the floor leader.
Favorable. Thank you very much, Mr. President. Senate Bill 692 is also a joint committee on pensions bill. It just alters the due dates for certain reports prepared by the State Retirement Agency, and it corrects the requirements for participation in the state police retirement system's deferred retirement option program by linking the eligibility to years of employment rather than to years of service. There are no amendments, and so I move for the adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. On the report, any discussion, any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 692 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 768, Senator Jackson, Correctional Officers Retirement System Membership Clarifications, favorable.
Recognize the Senator from District 11 as the floor leader.
Thank you, Mr. President. Senate Bill 768 is also a joint committee on pensions bill, and it just clarifies that there are certain employees at the Maryland Department of Health who are members of the Correctional Officers Retirement System as a condition of their employment. And the bill requires the state retirement and pension system to transfer service credit earned by these employees in the employee systems to CORS unless an affected employee opts not to have the service credit transferred. There are no amendments, and move for the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 768 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 810, Senator Jackson, Board of Trustees for the State Retirement and Pension System, Investment Division, Compensation and Staffing Committee, favorable 2 amendments.
Back to the Pensions Committee.
Thank you very much, Mr. President. Senate Bill 810, as amended, is also a joint committee on pensions bill, and it repeals the objective criteria committee of the Board of Trustees of the State Retirement and Pension System. And instead, in its place, it creates a compensation and staffing committee of the board. The Objective Criteria Committee's responsibilities are transferred to the new committee, and the bill makes clarifying changes regarding the role of the executive director and the board's investment committee related to the chief investment officer's position and the payment of awarded incentive compensation and the use of consultants. There are 2 amendments. The first makes technical changes, and the second clarifies the role of the ED and the investment division related to the qualifications and compensation of the CIO position, and it clarifies the payment of awarded incentive compensation on retirement, and finally, the restrictions on the use of compensation consultants. I move for the adoption of the amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 810 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 980, Senator Quarterman, Natural Resources, Maryland Heritage Areas Authority, Funding and Grants, favorable with 2 amendments.
Recognizing Senator from District 2 is the floor leader.
Thank you, Mr. President. Colleagues, Senate Bill 980 modifies the amount and use of funding transferred from Project Open Space to our Maryland heritage areas. We all have heritage areas all across the state. I think we've all seen great things come from them. And I know that the Project Open Space is obviously a topic of conversation as well, but be known that this is authorizing and is only on the state side as money as well, so our locals will not be affected. There are a variety of other technical changes that are made. There's 2 amendments. One adds a sponsor. The technical change ensures at least $600,000 from Project Open Space fund that is transferred will pay for the operating expenses that already occur. So with that, I move the adoption of the committee report and ask for move the adoption of the 2 amendments in the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. Any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 980 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 1000, Senator Heddleman, Gaming, Sports Wagering Facilities, Request for Relocation, favorable with 1 amendment.
Recognizing the bill sponsor is the floor leader.
Thank you very much, Mr. President. This is not a joint committee on pensions bill, but it does authorize a competitively awarded Class B1 and B2 sports wagering facility licenses to submit a written request to the State Lottery and Gaming Control Commission to relocate a Class B sports wagering facility. The commission may grant a relocation request if the license was originally issued a Class B sports wagering facility license before October 1, 2023, and the new location for the sports wagering facility is within the same county and complies with the same exact specified location requirements. There's one committee amendment that clarifies the location change is subject to the approval of the Sports Wagering Application Review Commission. I move the adoption of the amendment and the favorable committee report.
Floor leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now is on the amended report. Any discussion? Yes, recognize the senator from Prince George's County. A question on the report?
Yeah, thank you, Mr. Chairman. Will she?
Was Florida? Yeah. Senator may proceed.
Thank you. Just like to know a little bit about the bill.
Yep.
What challenges are currently inherent with the location of existing sports betting places, and why would they seek to move?
So I'll tell you exactly. There's an owner of a license in my district, and he is closing down where he is and would like to transfer it to another location that also meets the same specifications. And that's, yes, same owner.
All right. On the report, any further discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 1000 is hereby ordered printed for third reading. I think that does it for that calendar. All right. That does it for B&T as well. Let's go to judicial proceedings. Report number 21. Clerk will read the first bill.
Senate Bill 179, Senator Smith, motor vehicle registration fee exemption on employable disabled veterans. Favorable, one amendment.
Recognizing the chair of the committee is the floor leader.
Thank you very much, Mr. President. As amended, this bill establishes that a vehicle owned by or leased to and personally used by a veteran who is unemployable due to a service-connected disability is exempt from vehicle registration fees. Only one vehicle per unemployable veteran can be exempted from the registration fee. Mr. President, there's one committee amendment. It just adds the entire committee as co-sponsors. To pass the committee unanimously, I'd move for the adoption of the one committee amendment and the favorable committee report.
Floor leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now on the amended report. Any discussion? Oh, yes, recognize the senator from the 28th on the report.
Yeah, thank you, Mr. President. Question for the floor leader.
Senator may proceed.
Yeah, thank you, Mr. Chair. So there are several levels of unemployable disabled veterans. Does this bill specify at what level unemployability, or any level, whether it's 80 or 90 or 100%?
It's a federal definition. It's just it's unemployable service-connected disability that makes that veteran unemployable. According to MVA's analysis, there's probably 4,000 Marylanders that could potentially qualify for this.
4,000.
Yeah.
Okay. Thank you.
Thank you.
Chair.
Excellent. All right. On the amended report, any further discussion? Any objections? Without objection, the favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 179 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 205, Chair, Judicial Proceedings, Human Services, Adult Protective Services. Favorable, three amendments.
Recognize the senator from Montgomery County is the floor leader.
Thank you, Yikes. Try one more time. Thank you, Mr. President. SB 205 is a departmental bill. It specifies that in relation to adult protective services, disclosure of information is not prohibited to an officer or employee of any state or local government or the United States if the officer or employee is responsible for conducting an investigation in an official capacity, and this disclosure is relevant to the investigation. The identity of a person who makes a mandatory report of the potential abuse, neglect, self-neglect, or exploitation of an alleged vulnerable adult may be disclosed if in accordance with the aforementioned provisions. There are three committee amendments. Amendment number 1 is technical. Amendment number 2 requires an individual who must notify certain entities regarding abuse, neglect, self-neglect, or exploitation of an alleged vulnerable adult to do so as soon as possible. It also adds that the notification may be given by calling the statewide reporting hotline. Amendment number 3 changes the effective date of the provisions, altering the definition of health practitioner to be effective on July 1, 2026. Move the amendments and the favorable committee report.
Floor leader moves for the adoption of the three committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the three committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 205 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 608, Senator Augustine, Criminal Procedure U, Non-Immigrant Status Petitions, favorable, 3 amendments.
Recognize the chair of the committee.
Thank you, Mr. President. As amended, this bill makes changes to the process related to obtaining a certification related to the non-immigrant visa in the Maryland statute. Among other things, the bill creates a rebuttable presumption that a victim who has not unreasonably refused to cooperate has been helpful. It alters the time frames by which certifying entity is required to make a determination on that certification, and it prohibits the certifying entity from denying certification solely due to the amount of time that has passed since the qualifying crime occurred. Mr. President, there are 3 amendments. Amendment number 1 is technical. Amendment number 2 creates that rebuttable presumption, and amendment number 3 alters the timeframes that were required for determinations. I move for the adoption of the 3 committee amendments in the favorable committee report.
Floor leader moves for the adoption of 3 committee amendments in the favorable committee report. On the amendments, recognizing the minority whip.
Thank you, Mr. President. I wonder if the floor leader would yield.
Will the floor leader yield for
a
question? Senator may proceed.
I was looking through the bill, Mr. Chairman, and I know we passed a law a few years ago about this, about U visas. This was several years ago that this has been in Maryland statute. So I'm curious about the change on statute of limitations, which I understand one of the amendments made some adjustments to that. But so a certifying entity, which I assume is a certifying entity, a court, or is it federal, or what is the certifying entity?
Certifying entity is a state level entity, and usually like a state's attorney or a law enforcement agency, chiefs, sheriffs, police agencies, any state agency or entity that's responsible for investigating a certain crime.
That they may not decline certification so of the U visa, I guess is what we're saying there, solely based on the amount of time that has passed since a qualifying crime was committed. So I guess I always thought it would be the state's attorney would want to give them the certification because that's how they entice them to be helpful.
Right.
So why do we need to tell them? Was there a statute of limitations before?
No, there wasn't. So just to kind of step back, obviously this was created by Congress for back in I think 2000, right? This is to help folks that were being trafficked, human trafficking, and then also for victims or of domestic abuse. And so we don't approve the U visa. We just certify and send that up to the federal government. So just to understand that process.
Right. Okay.
But the reason to get rid of that time bar and to make it clear that there should be no statute of limitations is because if you are the victim of a qualifying crime and you go to a certified, like a state's attorney or a sheriff or a chief, you want to be able to go back as far as possible. You don't want to just time bar someone because they were a victim of a crime 4 years ago, 5 years ago.
Why wouldn't they? I'm sorry to interrupt you, but why wouldn't they be applying for it as soon as they're involved in helping with the crime? I guess, or shortly thereafter. Why would it be 10 years later or 12 years later?
There are a multitude of scenarios where if someone was reoffended or someone was re-victimized and then said, hey, look, actually, you know what, I'm going to apply here. The original crime happened a long time ago. Or, hey, look, I'm going to go ahead and apply for this status right now because I feel like it's time for me to come forward. It's just there are a multitude of different fact scenarios that would apply.
I guess I thought the goal of the U visa was to provide protection for a victim, but also incentivize cooperation with law enforcement.
100% accurate.
So this seems, I guess this acts like law enforcement wouldn't want to give them. Why would law enforcement not want to give them this certification already, or why wouldn't the state's attorney or whoever not want to give them this certification?
No, I think it's a matter of resources and availability of evidence. And so, for instance, in my home county, I think they have a practice of going back or limiting going back to 7 years. And that is probably because a resource thing, but also the availability of evidence.
Oh, because the person may come forward and say, this crime was committed against me, but if you go back, obviously that could happen. You also have to vet whether the person's just saying that versus because they're trying to maybe stay in the country, right? I mean, is that fair to say that that could happen sometimes?
That certifying entity has that burden of just saying, hey, look, this is a valid application, I'm going to send this up. And then there's another stage of verification at the federal level. So you're not going to get a U visa that's ultimately issued to someone that is for nefarious or unfounded purposes.
What is there any requirement that it be something that the certifying entity wants to investigate or go after? Or can you just apply for a U visa and say, I was I mean, again, I'm not making light of it, but I mean, can you just apply and say, I was harmed, I was abused, or some other crime was done to me 6, 7 years ago, 5 years ago, and I'd like a U visa, whether the police are pursuing it or not, or whether the law enforcement's pursuing it or not?
I suppose you could, but then the certifying entity has that responsibility to investigate, make sure that it's a valid application before they send it up. So, I mean, you could apply, but it wouldn't get, that application wouldn't get forwarded
Because
along.
they would say it's not irrelevant.
Yeah,
or
exactly. They would say
okay.
it's not a helpful.
Mr. President, I know we've had a lot of layovers, but I'd wonder if I could just have a little more time with this, and then we'll get to it next session. So I asked for a layover. I guess I should make the official motion.
There we go. Senators move to lay over the bill. Its motion is in order. The bill and the amendments will lie over under the rule. Clerk, read the next bill.
Senate Bill 856, Senator Henson, Mold Landlord Requirements and Regulations, Maryland Tenant Mold Protection Act, favorable with one amendment.
Recognizing Senator from the capital cities, the floor leader.
Thank you, Mr. President. Senate Bill 856 requires the Maryland Departments of Environment, Health, Housing and Community Development, Labor, and General Services to put together a centralized website with information on mold remediation and dampness. It also requires them to create an informational packet of resources as well. In addition to that, it establishes that mold assessment and remediation, that certain conditions for that will be required of landlords. There is one committee amendment. The committee amendment clarifies that instead of every 2 years, those resources will be distributed upon request of the tenant. The second committee amendment clarifies that a landlord must perform a mold assessment within 15 days, but does have 45 days to perform the remediation or a reasonable amount of time if the assessment reveals the need for remediation. Move the amendments in the favorable committee report.
Floor leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objection? Without objection, the one committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 856 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 883, Senator James, Commercial Law, Statutory Liens, Motor Vehicles Towed or Removed from Parking Lots, favorable with two amendments.
Recognize Senator from the 34th as the floor leader.
Thank you, Mr. President. This bill has two amendments. One is technical, and the other modifies the bill to create a work group to study procedures regarding towing, the potentiality of creating liens, and all in line with due process. The vote in committee was unanimous, so I move the two committee amendments and the favorable committee report.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 883 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 915, Senator Heddleman, Baltimore County, Vehicle Laws, Private Roadways and Residential Subdivisions and Communities, favorable with two amendments.
Recognizing Senator from the 42nd as the floor leader.
Thank you, Mr. President. As amended, this bill authorizes a police officer in the community of Queen Anne Village in Owings Mills, Baltimore County, Maryland, to enforce the provisions of the Maryland Vehicle Law on any private roadway that is used for vehicular travel by residents. This authorization expires after 3 years. There are two committee amendments. One is technical, and the second just writes the bill as I just described. There was no opposition to the bill. I hereby move the adoption of the two committee amendments and the favorable committee report.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 915 is hereby ordered printed for third reading. Clerk, read the next bill. That is not one to read because that is the end of that calendar. Let's go to report number 22. Clerk will read the first bill.
Senate Bill 80, Senator Kramer, Criminal Law, Animal Abuse or Neglect Penalties, favorable with 2 amendments.
Recognizing the chair as the floor leader.
Thank you, Mr. President. As amended, this bill prohibits a person from committing a violation of the existing prohibition against abuse or neglect of an animal of the criminal law article that results in the death of a domestic animal or livestock. And number 2, the need to euthanize the domestic animal or livestock based on the recommendation of a licensed veterinarian if the decision to euthanize a domestic animal or livestock is validated before or after the euthanasia by a second licensed veterinarian. Violators are guilty of a misdemeanor and on conviction subject to imprisonment of up to 1 year and or a fine of up to $5,000. A court may impose conditions of sentencing and probation, including prohibiting the defendant from owning, possessing, or residing with an animal for a period of time determined by the court. This is an emergency bill. Mr. President, there are 2 committee amendments. Amendment number 1 is technical and adds co-sponsors, Senator Smith, and amendment number 2 strikes the provisions of the bill and establishes the new prohibition as specified. Mr. President, I move for the favorable adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 80 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 343, Senator Sidnor, State's Attorneys, Reconstitution of Task Force and Establishment of Case Management System Grant Fund, favorable with 1 amendment.
Recognizing the senator from Baltimore County as the floor leader.
Thank you, Mr. President. Senate Bill 343, as amended, reestablishes a task force to study transparency standards for state's attorneys, which was created back in 2022. It was amended, striking language that was going to create a case management system grant fund, and it also alters the duties of the task force. Mr. President, I ask for the favorable report on the amended, or adoption of the favorable committee report and the amended bill.
All right, floor leader moves to the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the 1 committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 343 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 466, the President, Vulnerable and Senior Adults Theft of Property by Caregiver, Family Member, or Household Member Prohibition, favorable with 2 amendments.
Recognizing the Vice Chair of the Committee as the floor leader.
Thank you, Mr. President. As amended, this bill prohibits a person who is a caregiver to a family member or household member of an individual from knowingly and willfully exerting unauthorized control over and obtaining the property of the individual with the intent to deprive the individual of that person's property. If the individual is a vulnerable adult and the person knows or reasonably should know that the individual is a vulnerable adult, there are 2 committee amendments. Amendment number 1 is technical. Amendment number 2 strikes provisions of the bill. The vote in our committee was unanimous. Mr. President, I move the favorable committee report and the 2 committee amendments.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 466 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Bill 621, Chair, Judicial Proceedings, Courtroom Security, Minimum Adequate Security Standard, favorable with 2 amendments.
Recognize the Vice Chair of the Committee as the floor leader.
Thank you, Mr. President. Senators, as you know, there's been a recent incident at one of our courthouses. This bill helps in response to that. As amended, this bill requires that by September of this year, each law enforcement agency, department, or entity that provides security at our courthouses must submit a report to the Chief Justice of the Supreme Court identifying information regarding the implementation of certain security standards. There are 2 committee amendments. Amendment number 1 is technical. Amendment number 2 strikes provisions of the bill and alters the bill's reporting requirement. Mr. President, I move the 2 committee amendments and the favorable committee report.
Did the city weigh in on this one by any chance?
Sorry?
Did the city weigh in on this one?
I believe we have not heard from the city.
Okay, all right, just wondering if there's, okay.
Thank you, Mr. President.
All right, on the 2 committee amendments, that the floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 621 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 626, Senator Folden, Frederick County Sheriff's salary, favorable with 2 amendments.
Recognize the senator from the 42nd as the floor leader.
Thank you, Mr. President. This bill alters the annual salary of the Frederick County Sheriff by establishing that the annual salary beginning in calendar year 2026 will be 82.5% of the Frederick County State's Attorney's annual salary. Any change in the salary may not apply during the sheriff's current term of office, but the changed rate must take effect at the beginning of the next following term of office. There are 2 committee amendments. One is technical. The other alters the provisions of the bill relating to the sheriff's salary. There was no opposition to the bill. I hereby move the adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 626 is hereby ordered printed for third reading. Clerk will read the next bill. It's the last one. Sorry. Let's go to Report 23. Clerk will read the first bill.
Senate Bill 280, Senator Simoner, Judicial and Public Safety for Service Members Act, favorable with 1 amendment.
Recognizing the chair of the committee as the floor leader.
Thank you very much, Mr. President. As amended, this bill generally establishes uniform definitions related to the military in the correctional services, courts, and judicial proceedings, criminal law, family law, general provisions of public safety, real property, and to state government articles of the Maryland Code, primarily by reference to definitions to the U.S. Code. While numerous alterations within the bill represent only stylistic or technical changes, there are substantive changes. These changes generally make certain provisions, including those related to the court fees, and more broadly applicable to the additional service members. Mr. President, there are no committee amendments. We move for the, actually, there's 1 committee amendment that adds sponsors and makes a technical correctional change. Mr. President, I move for the adoption of the 1 committee amendment and the favorable committee report.
Floor leader moves to the adoption of the 1 committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the 1 committee amendment is adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 280 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 281, Senator Simoner, Transportation Equality for Service Members Act, favorable with 2 amendments.
Recognizing the chair of the committee.
Thank you very much, Mr. President. As amended, this bill generally establishes uniform definitions related to the military and the general provisions, state government, and transportation articles in the Maryland Code. There are 2 committee amendments, Mr. President. 1 adds co-sponsors. Amendment number 2 restores certain existing definitions. I move for the adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 281 is hereby ordered printed for third reading. We have that one that we were looking for at a triple E. Are we recognizing the chair? Well, let's call up the bill if we could. This is 770. Madam Clerk, if we could read the bill.
Senate Bill 770, Senator Guile, applicants for positions involving direct contact with minors, required information, review process, and reporting, alterations, favorable.
Recognizing the chair of the committee.
Thank you, Mr. President. Can we special order to the second session? That was actually, the intent was supposed to be for the later session, so we could special order to that second session.
To the evening session? Oh.
The evening session. Oh, well, actually, the floor leader does have the document, so let's just roll with it now, okay?
Yeah,
never mind.
Very
Strike
good.
that.
It's very good. Strike that. We're on it. Recognize Senator from the 23rd as the floor leader.
Thank you, Mr. President. Thank you, colleagues. Colleagues, this bill requires child care centers and youth-serving organizations to follow certain procedures when hiring applicants for positions involving direct contact with minors by requiring the submission of information about the applicant's boundary-violating behavior. The bill also requires a local board of education, non-public school, or contracting agency, in addition to a child care center or youth-serving organization, to request the Child Protective Services background clearance before hiring an applicant. There are 3 committee amendments. The first is technical. The second requires a local school system to provide crisis support and assistance to a public school in the county when a teacher or other school employee with direct contact with minors is removed from the classroom or school building due to alleged criminal activity or student safety by establishing a specified crisis response team and standardized crisis response protocols. Amendment number 3 strikes the bill as drafted and requires the State Department of Education to convene a stakeholder work group to examine the impact on the public school system in the state of adding a requirement to the hiring process for applicants for a position involving direct contact with minors to include information regarding the applicant's history of boundary violating behaviors and youth serving organizations in the state, adding requirements for hiring personnel and organization registration with an appropriate government agency. Specifically, the work group must review certain proposed definitions. While the bill as introduced has significant operational and fiscal impact on state and local agencies, we believe the bill as amended by the committee greatly reduces these impacts. I move adoption of the 3 committee amendments and the favorable committee report.
Floor leader moves to the adoption of the 3 committee amendments and the favorable committee report. Recognize the Senator from Anne Arundel.
Yeah, I'd like the special, oh, this is the wrong bill, never mind.
All right. And the amendments, any discussion of the amendments? Any objection to the amendments? Without objection, 3 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 770 is hereby ordered printed for 3rd reading. All right, we are going to take a 5-minute break. Make sure there are friends from the Secretary's office get a chance to stand up and get a moment. So if we could do a quick quorum call.
Mr. President.
Has everyone recorded their presence? If so, the clerk will take the call. With 46 members in the chamber and a quorum being present, the Senate of Maryland remains in session, recognizing the majority leader.
Thank you, Mr. President. I move the Senate of Maryland adjourn to a new legislative day, and we have a 5-minute break.
5 minutes. Without objection, so ordered. Truly 5